We first of all want to begin by acknowledging the traditional owners as well. I'm coming from Wurundjeri country, and I would like to acknowledge, of course, that the sovereignty was never ceded on the country that I am on, nor many of your countries that you're all coming in from. So I'm a lawyer at Social Security Rights Victoria. I work in the family violence program at SSRV, and in my other parts of my life, I work as a senior lecturer at UNSW. So I juggle kind of a few balls around. This has been fun so far today. I'm just going to, invite Beck, if you want to just introduce yourself first, Beck.
Sure. Hi. So my name's Beck Glenn, and I'm the founder and CEO of Centre for Women's Economic Safety, which is a registered charity that exists to support women experiencing economic abuse in the context of domestic and family violence. And I'm joining you today from the unceded land of the Gadigal people of the Eora Nation. Hi.
Hi everyone, I'm Jasmine Opdam. I'm the team leader of the Financial Abuse Service New South Wales at Redfern Legal Centre, which is a legal service which provides free advice and assistance to victim survivors of financial abuse in an intimate partner relationship in New South Wales. We also coordinate the New South Wales chapter of the Economic Abuse Reference Group. I'd like to acknowledge that I'm joining from Camaragal land in Sydney today, and acknowledge that sovereignty was never ceded.
Thank you. So we're going to be going through some case studies, which I'm just pulling up onto our screen. I can find the screen for me. And our case studies are all based in reality, so I'm sure many of them will be quite familiar to all of you. All right, I need our PowerPoint. There we go. Can you see that?
Yep.
Yep, great.
We can see that.
All right. Bear with me.
Shall I do a bit of a setup?
Yeah, can you just, I might just pause that for a moment. Is that okay?
Yep.
Beck, do you want to share them? Have you got them up?
Yeah, I can do that.
Yeah, great, thanks.
Okay. All right, so the case studies that we're going to share with you today, all of them are from women who have experienced coercive control and or other forms of domestic violence. And I guess before we sort of get into them, I think it's worth saying we're just sharing a little snippet with you of what is a much more complex story. And the economic abuse that we're going to be talking about, I'm sure many of you on the session are already familiar, but I don't want to presume that everyone understands what economic abuse is. And so we'll start with just a quick definition. And it is a really common form of domestic and family violence. We know something in the order of 85% of women experiencing other forms of domestic and family violence are experiencing economic abuse as part of that broader pattern of behaviour. And it's basically when you see one person restricting, exploiting or sabotaging another person's economic resources. So that could be money and finances, it could be housing, food, transport or employment. And the effect of those behaviours is that it limits the other person's autonomy and undermines the economic security they otherwise would have had. So there are a range of ways that can, many tactics of economic abuse. Some of the really common ones that I'm sure, Pamela and Jasmine have seen plenty of, and no doubt many of you on the session. Not being allowed to have a say in household finances, being coerced into debt that you didn't otherwise want or didn't get any benefit from, or having your employment undermined, making it very difficult for you to hold down a job, or simply not being allowed to work at all. And of course, some of the things that we'll talk about today are the ways in which economic abuse is also perpetrated through things like social security. So being forced to perpetrate a fraud to get social security could be one example, one that I've certainly seen a number of times. So let's get into the case studies, and I think we've got 3 to share with you today, and we were going to just have a conversation off the back of each of these to unpick some of the issues about the way social security is designed and the impact that can have on people experiencing domestic and family violence, and particularly economic abuse. Okay, so I'll read the first one. This is from Lainey, in her own words, a narrative that we published on the Centre for Women's Economic Safety website. We were separated, but we still lived under the same roof because I didn't have anywhere else to live and I couldn't afford to rent on my own. He threatened to ruin me financially. My second child wasn't quite 1 year old and I couldn't get them into childcare. That meant I couldn't work and had no income at all. One day, he removed my credit and debit card from my wallet before he left for work. Another day, he took the car keys so I couldn't drive anywhere. I felt very trapped because I knew the government couldn't easily provide me a parenting payment. I'd contacted Centrelink to find out what I'd be eligible for, and they said it would take 6 weeks for me to get a single parent pension. And I said to them, okay, so what happens if I need to get out of the house quickly and I need some money to pay rent somewhere? And they said they could offer like $500. And I was absolutely baffled. I thought, how do people leave? There must be so many women like me that are absolutely stuck. You're on mute, Pamela. And I'll just stop sharing there.
Sorry, thank you. Okay, Beck, I think you were going to talk about this from a human rights kind of lens a little bit. Do you want to elaborate a little more?
Yeah, so I mean, the idea, I think we all accept that there's a human right to be free of violence. And of course, the Human Rights Charter has another clause around the right to a standard of living adequate for the health and well-being of people and their family. And I think that the way our social security system is currently set up is that it's almost suggesting you can have one or the other, but not both, because so many people, because of this couple rule, which expects people to, if you're a couple living together and one person earns money and the other doesn't, that of course that person with the money will care for and look after the other person and people in that household. And of course, particularly in the context of domestic and family violence, simply not the case. And yet our safety net is not providing a safety net in those circumstances. Neither is the system holding to account the people who are not doing what it is that society and the systems are expecting of them. And so I think if we can take it back to the human rights of people deserve to live free of violence and people deserve to have a standard of living adequate for their health and well-being, then I think we can say the system's not working.
Yeah, there's so many assumptions about relationships and families and things built into the system that cause huge problems, and I'm sure everybody here sees. Jasmine, I think that, I think the case study, Lainey says, how do people leave? And so, how have you seen, I'm sure you've seen women experience that, and how would you see the lack of social security support system affect victim survivors' economic insecurity and therefore their safety? Do you want to elaborate a little bit about that?
Sure. I think many people joining today and indeed working in the sector would recognise that this lack of social security support is a contributing factor to financial insecurity. But what I'd like to delve into a bit more is what that financial insecurity means for victim survivors of economic abuse, particularly for women on temporary visas who aren't eligible for Centrelink, and for other aspects of the financial security blanket, if you want to call it that. And recognise that financial insecurity is one of the key reasons victim survivors actually stay in or return to abusive relationships, like Lainey, who's stuck under the same roof as her abuser because she can't actually afford to get away and establish, a second household. In our financial abuse service, we assist clients across New South Wales who've experienced financial or economic abuse in an intimate partner relationship. In the last financial year, 95% of our clients, so almost all of our clients, were currently experiencing financial hardship when they came to us for advice, even though in many cases, the abusive relationship had actually ended years earlier. And 5% of our clients were homeless or at risk of homelessness. So I think that shows from the lens of economic abuse and domestic abuse that this scenario is so common. And when you couple that economic abuse with insufficient social security support, it's really putting women particularly in a situation where they're forced to choose poverty over violence. But I put that in quotation marks because we all know that isn't a real choice.
Yeah, we see it at SSRV too. I'm sure like lots of member centres and other services see it too. And we see instances where the system is sort of, it's designed in such a way that it inflicts harm on victim survivors too, because, you know, for example, they can end up with that family tax benefit debt, overpayment debt. They could end up with debts for failing to report income, or because they had no way of knowing that their partner earned income because of the things that Beck was describing before, like people don't genuinely share, you know, the information or even just finances generally. And they can, of course, end up with, you know, being ineligible for payments, like the parenting payment can only go to one parent. And if you've got 50-50 care, it's just so out of sync with what is genuine. I mean, I'm just wondering then again, Jasmine, if you have any more thoughts about the way the social security system can be abusive by design, like it can be a tool of economic abuse. So we heard, you know, in our opening sessions, I think there was a comment made about how the system has systemic racism in it. And I'm just wondering more, I suppose, about how the system is systemically abusive to family violence victim survivors too. So we have systemic racism, we have systemic, essentially, abuse of people who've experienced family violence. So it's not necessarily perpetrators using the system to abuse victim survivors, though that does happen, and we'll talk about that in a minute. It's also the system itself being so rigid and you know, outdated and inflicting harm. Do either of you want to comment on that?
Yeah, I'm happy to jump in from our casework experience. I think the language that you were using, Pamela, around kind of systemic abuse is a good way of thinking about it, and even systemic misogyny, I guess, in terms of the gendered assumptions that it makes. And the social security system is not unique in this respect. Many aspects of our legal and financial system are designed in this way, with outdated assumptions about how finances are shared in a relationship, which Beck mentioned, like the couple rule, how information about finances is shared or not shared, like knowing and then being able to report to Centrelink any income that your partner has earned, assumptions about who controls the money, who makes the financial decisions, who should be the person signing on to, you know, debts and mortgages and financial documents. So these assumptions are typically very gendered. And the impact for victim survivors of economic abuse is that they're up against not just their abuser, but also the system itself. And we see so many victim survivors ending up in a debt spiral because they're taking out lines of credit just to pay bond and furnish a new rental after escaping family violence, like in Lainey's situation. And then they're going without meals or essential medications so that they can keep meeting those repayments. And there are some really alarming statistics around economic insecurity in that respect. And, you know, the numbers and percentages of people who are using buy now, pay later products to purchase essential items, to pay for childcare, for that kind of everyday living. Because the social security system over the last few decades has been reframed kind of from this idea of social justice to what Anne Summers in her violence or poverty report called moral hazard, where it's now synonymous with poverty in many aspects. There's that high intersection between people experiencing family violence and then being essentially forced to choose poverty. And that all, I think, flows back to those very gendered assumptions that are built into the system and that really need a bit of a refresh.
Yeah, if you've got people who are making the choice, using the same quote marks, air quotes, as you are, that living in the car with your child or children is preferable to living with financial security with the perpetrator, then something's gone horribly wrong with the system. And I think to the point about, you know, system design being abusive in design is that shift that you talk about, Jasmine, is that built into social security now is an assumption that you're probably trying to have the system on. You're probably trying to perpetrate a fraud here. That's the starting point. And if you're you know, experiencing abuse from a partner or family member or carer or other person in your life you rely on, it's a pretty confronting and unhelpful starting place from the one place we say officially exists to provide you support when you most need it. And so I'm certainly a very big proponent of taking and using people's lived experiences to help redesign that system. And so when we heard just a little earlier from the Minister Bill Shorten about him being open to the idea of there being a formal way to introduce lived experiences in system design. I know they were talking, I don't think they were talking specifically in the context of domestic violence, but really all elements of the system. If we were to introduce and have at the table people with lived experience insights to explain in the way that I hope, just to a very small extent, some of these case studies will do, how the system doesn't work, how the system undermines safety, autonomy and dignity, that then we could actually have a chance of designing something that could once again do what it was originally intended to do, and that support people who have found for a range of reasons themselves in unenvious circumstances.
Yeah, I think it like the AAT, it needs a large rework, doesn't it? Beck, do you want to just maybe run through our next case study with Alice?
Yeah. Okay, so this case study comes from friends at the Redfern Legal Centre, and it's about Alice. I should say Lainey, Alice, and all of it. These are not their real names. Alice is a woman in her 60s who has moved out of the former matrimonial home. She hadn't worked over the course of their marriage, and she only had a few $100s in her personal bank account at the time of separation. Prior to separation, she had to ask her husband for money and account for her expenditure. She's been homeless since separation. She couch surfs between friends and family, and her application for the job seeker payment was rejected because of the asset value of her jointly owned home, which was occupied by her estranged husband. While her husband had been controlling, he had never been physically violent. Alice was granted a low-income healthcare card after social work intervention. However, she was left dependent on the charity of others. It wasn't until that local community legal centre got an asset hardship form and worked with a social worker to reactivate her application with more information that she was actually able to access benefits.
We see this as well in our service. You know, we see victim survivors in this situation, and that asset hardship provisions that you've just mentioned there, you know, that can be used because the home is an unrealisable asset. So, you know, sometimes it only works for a short time, because then if eventually it becomes deemed that, oh, well, that's realisable through a family separation, then that's, you know, it's not a long-term solution, but it might be a short-term kind of solution for somebody in Alice's situation. You know, there can be other problems that I've seen very recently around Centrelink saying, well, we're going to deem income on the asset. So even though the asset, we're going to not worry about the asset, but, you know, we're going to deem income as though you would be earning rent from your former partner, and the perpetrator's not going to pay a rent, right? So you know, it can be really complex, and she probably has multiple problems stemming from the presence of that apparent asset that she can no longer live in and use. So I don't know, Beck, if you want to comment a bit more on perpetrator accountability and things like that, or if you want to, you know, elaborate. What do you think?
Well, it's just, again, I mean, unhelpful assumptions at the heart of the way the system's working. The other thing I'd just note is how often, if there is any way to better support someone that falls outside of the strict criteria, that information is often not well known, easy to find, or easy to connect with the person who actually needs that information to be able to make their decision. So I think there's another issue there about how do we make information relevant to the decision at hand easily available and understandable for people who need it. But yeah, to your point about the perpetrator accountability, you know, as with, you know, I think was it Laney, there isn't a mechanism currently to hold perpetrators to account. So in this situation, we've got a perpetrator holding and occupying a joint asset, which is making life almost impossible for Alice. And there is no attempt at any point, I don't even know if the mechanism exists, you two are lawyers, maybe it does, but why are we not holding the perpetrator to account for tying up the assets in a way that means someone is couch surfing? It's so often the case that any potential for redress is a burden that is placed on the victim. So if she wants to challenge that, it's up to her to get a lawyer, get the evidence, take the case to court. And we are talking about a situation where the power imbalance already was against her. And so I would like to see systems where there is power doing more of the heavy lifting to redress that power imbalance than and expecting and putting the entire burden on the person who's already, you know, got so little. So yeah, I think we've got a lot more to do about how we hold perpetrators to account.
Yeah, I agree. And clients will often feel, you know, very frustrated at that with me because they might have a family violence related debt, you know, usually a family tax benefit debt. And, you know, during the relationship that was assessed on the basis of this kind of, you know, family income. And then they end up with this family tax benefit debt. And they'll say to me, but how come they don't have to pay half? Like it seems really, really unfair. Jasmine, I don't know if you would like to, you know, elaborate on how you see perpetrators using the system as a tool of economic abuse as well.
Yeah, I think what we see particularly in our service, and because we have both a family law, I guess, to our service, as well as credit, debt and consumer law specialists, is we see perpetrators of economic abuse who are incredibly sophisticated at both hiding their assets to avoid, you know, paying child support, for example, or protecting their assets from property settlements in the family court. And that might be even selling an asset like a matrimonial home to a third party to try and avoid it being wrapped up in the asset pool. And it's prohibitively expensive for victim survivors who are struggling just to get Centrelink payments, for example, to then engage in that property settlement process, not to mention the time and the trauma of spending years in the court system. And we see these legal systems really lending themselves to systems abuse. So that's one of the reasons that our service isn't means tested, because we've worked with victim survivors who have had very valuable family homes on paper, who have had, you know, incomes running into hundreds of thousands of dollars a year on paper, but no access to their income, and all of that money being funneled into bank accounts controlled by their partner and used to pay, you know, household bills, all with no visibility over that process. We also often see the flip side to Alice's situation, where rather than the perpetrator being left in the family home and kind of controlling that asset, the perpetrator might move out and say, okay, well, if you want to end the relationship, so be it, move out. In that case, I will stop paying the mortgage, I'll stop paying the council rates, I'll stop paying all of these household bills, and then you can deal with the fallout from that, which might be receiving threatening letters from the bank, threatening to foreclose. It might be potentially being taken to the local court, which we see quite a lot in New South Wales, when the local council is pursuing local council rates and sending debt collectors after them. And that requires this wraparound kind of collaboration between our family lawyers and our credit, debt and consumer lawyers to really untangle what's going on and sort of keep debt collectors, keep banks at bay while the property settlement process can happen through the family court. And all of this burden falls on victim survivors in circumstances where they're already experiencing such awful economic insecurity. And one of the most common questions that our clients say to us, if they're coming to us while they're still in a relationship, with all of the safety concerns and considerations that goes along with that, is often they'll come to us for information and they'll say, I want to know my rights. I want to leave this relationship, but I don't think I can afford to leave. Or they might say, I know that we have mortgages. I know that we have debts. I feel like we're in a lot of financial stress, but I have no idea how much of that falls on me, or what our financial position looks like, or even whether I might be eligible for Centrelink. And that's even where they know that there's debts in existence. We also see the issue of company debts come up quite frequently, where a victim survivor might have been made a puppet director of their partner's company, even without their knowledge. But even though they have no idea what's happening with the company, they have no control over it, they have no access to the company assets, they find themselves knocked back from Centrelink when they leave the relationship because they're listed as a director. So this process, I think from our perspective, looking at our casework experiences, is really onerous for victim survivors. And on top of everything else they're dealing with, and that might be criminal proceedings, it might be AVO proceedings, it might be family court proceedings and everything else, is untangling all of this when their first priority is just getting access to money so that they can escape the relationship.
Yeah, really agree with that summary. Thanks, Jasmine. Do you want to run through our third case study, Beck, which is for Deb?
Yep. Okay, so it's in her own words. This case study comes from Inside Exchange at Domestic Violence Service Management. He made me go on the single parent payment so that if he ever felt like not working or if we had a fight or whatever, I'd have money. We'd often have a fight and he'd disappear for 2 days, go through his money and come back 2 days later and rely on my money. But I was being made to take the risk there, being with him and being on the single parenting payment. He'd threaten me. He'd go, well, I'm going to go and tell Centrelink.
Yeah, I have quite a few clients that would really relate to this very, very powerfully. So, you know, from my perspective, the social security problem here that Deb, I see, is facing immediately is that if Centrelink find out that she's been claiming a payment at the higher rate instead of the single rate, then, you know, the partnered rate being different, then they would raise an overpayment debt for the difference. And Centrelink's hands are quite tied at the moment for special circumstances waivers of debts where a person has knowingly misled Centrelink. So, you know, I've had a client recently who had kind of a combination of the last two scenarios. One where she's been listed as a company director, and then also, you know, has experienced this problem of receiving a payment at a rate that she shouldn't have received it at. And so I think that they face these big hurdles where with overcoming the special circumstances issue where, you know, their partner or maybe even the client themselves did know. And sometimes the client might not have known, like because there might be a language barrier or there might be some sort of, you know, perhaps they have no control over what they've applied for and their partner controls all of that. And sometimes they really genuinely had no idea, but their nominee might have had an idea. And so there's, so, you know, it becomes very difficult to apply for special circumstances waiver. And then the other option open to Centrelink is for them to use their discretion to treat the person as not being a member of a couple, because the 5 characteristics of being a couple under the Act are not present during the relationship. And we have at SSRV successfully argued this for clients at various stages, and often ends up in the general division. But, you know, again, it is quite difficult to convince Centrelink to apply that just at a review officer level, particularly, and even at higher levels. And so Centrelink has previously been willing to, with one of my clients, to even call a perpetrator in the general division, where, you know, there was profound family violence. And that's kind of, I'm just using that as an example of the extent to which they will go to avoid having to apply this Section 24 discretion. So, you know, in that matter, we were really fortunate. We asked for a directions hearing, and then we were able to explain to the member that we didn't think that perpetrator would be a credible witness. And then Centrelink was willing to settle after that. But, you know, the fact is, I think that somebody like Deb faces a really big uphill climb in getting out of the debts that Centrelink raises because they've claimed the wrong level of payment. And just, you know, Centrelink's just going to look at it from a very factual, it was not the right level of payment, and their hands are unfortunately under legislation relatively tied. So I don't know, Beck, if you've got more thoughts about that situation, or what your thoughts are.
Firstly, I think, as you say, there's the change that I would like to see is to get rid of this couple rate and single rate, and that everyone deserves a payment regardless.
Yeah.
You know, we know that people share houses who are not in intimate partner relationships and can get a single payment each. Like this false idea that, you know, yes, you can save money, but therefore you've got to include all of these sort of complicating factors which undermine safety and options for people. So that's the change I'd like to see, but I understand that is going to cost money, and we've heard pretty clearly from the ministers that they're a little bit concerned about spending any more money. But to your point about that special circumstance waiver, you know, they can, for the sake of a piece of legislation, change that so that they can include that waiver even when a person knows what they're doing but have been coerced into it. So you know, I think that's a change that can be made, and I would like to see the government take action on that really quickly, because it's so deeply unjust. I guess the broader point I wanted to make here was just, and I guess this applies also for disability support payment, but this idea of the way in which the system ties people who are dependent or vulnerable for whatever reason to a person with greater power, and therefore enables that person to extend their abuse. So, you know, women with a disability who we know are amongst experienced economic abuse at the highest rates of any cohort. They are often on a disability support payment, unable to work but maybe want to work, or can work but inconsistently work. And so they've got this, I guess, increased vulnerability because they can't compromise the continuing payment of the disability support payment by working. So they're forced into sort of illegal work with fewer protections and so on to make ends meet. And as one person put it to me, a woman with a disability, she said, I feel like the government's controlling who I can and can't have a relationship with. Like if I have a relationship with, if I move in with a partner who's earning money, I lose the disability support payment, rendering me entirely dependent on them, requiring them suddenly to take on a whole range of medical bills and other things. She really felt that the government overreached there, that meant she loses her financial independence, was actually having an impact on her life choices. So I think disability support payment is another area where the system design assumes that people look after each other and things don't go wrong, and that people don't deserve a support in their own right. And I'd like to see that change.
Yeah, I've certainly seen something quite similar recently around age pension, and their other partner was not anywhere near of working age yet. Of age pension age yet. And again, it was really affecting them in a very similar way, actually. Yeah, it's terrible. Jasmine, did you have any further thoughts about Deb's scenario, or the ways in which people have issues accessing support and recovering, like from that perspective of recovery?
Yeah, I think Deb's scenario really, although it's specific to, the Centrelink context and having a Centrelink debt raised, is really emblematic of the sorts of legal issues and financial hurdles that we see victim survivors facing in, the weeks, months, even years after leaving a relationship, precisely because of those sorts of outdated assumptions made around, the sharing of finances and things like that. In our practice, we often see perpetrators who might have coerced their partner to, illegally claim insurance benefits or, take out lines of credit for their benefit and things like that, but also illegally claiming Centrelink payments because it's just part and parcel of that sort of economically abusive behaviour. But the issue, I guess, that victim survivors face, in particular with Centrelink debts, is that having been coerced to make false declarations, there's then this present threat from the perpetrator to out them to Centrelink or to other authorities. And victim survivors tend to see that at a different level of risk, I guess, compared to the prospect of telling a bank or a lender that a false statement was made, because this is a government agency. There are already so many stigmas attached with Centrelink and with the social security system. So I think something you said earlier, Pamela, around that kind of knowingly misleading Centrelink is part of the key problem, is that people who work in the family violence space would recognise that there's a difference between knowingly taking action and being coerced to take a particular action. And victim survivors are then, as you say, facing this uphill battle, like Deb, in trying to seek help from a legal service or a financial counsellor, because even doing that puts them in the precarious situation of having to admit to authorities that they made false statements, because the law doesn't recognise the intricacies of coercion and economic abuse. We also see perpetrators using social security payments for themselves, to use on gambling, drugs, alcohol, or for their other personal expenses, which again forces victim survivors into that debt spiral. So I echo all of Beck's points around these outdated assumptions about the sharing of finances. And I think it is really inconsistent with the push, I would say, and recognition in society and in our community, that having greater economic security and financial independence can be a protective factor against economic abuse. Yet we have a social security system that forces people, particularly women, into situations of financial dependency, whether that's on an abusive partner or not an abusive partner. I think that sits at odds with what we as a society in many ways are trying to achieve and trying to work towards, and ties in with broader systemic issues of gender equality, of the gender wage gap. We could talk about that for hours, but I think that there is that case of the social security system sort of lagging behind community expectations in many ways.
Yeah, absolutely.
Yeah, absolutely. And lagging behind just societal norms that have changed as well. Yeah. Just even like things like the joint bank account, which, it's an old-fashioned assumption that everyone's going to have a joint bank account.
Exactly. This assumption that on marriage, all finances will then be joined, into a joint bank account forevermore, that both parties will have complete visibility over all the finances in the relationship. And we see that play out with assumptions made by lenders and banks, assumptions made in the family court, and the social security system as well. And, I think we don't need to see the statistics to know that that's not the way in 2022 that most relationships work, or that most people are living their lives.
Yeah. So that's pretty well our little slides and our case studies that we had prepared. I can see a few little questions popping up in the in here. I've only had a chance to really read one of them, I think. Shall we just go through those? Would you like to do that, Leanne? That'd be
Hi, thank you so much for unraveling what is a really complex situation, but as you've all said, such an injustice. And most of you probably won't have heard yet, I did an interview on Radio National with Damien Carrick on the Law Report, where I've just said, you know, we can't let the complexity of this situation undermine efforts to address it. We can't have this injustice continue. So I was really heartened to hear Minister Rishworth in her interview with me earlier saying she would work with us on this, and we will be holding her to that. So to go to the questions, the first one is for you, Jasmine, and I think you've touched on this already, but the question is whether your service sees many people with Centrelink debts that they don't actually understand and who've been unable to appeal or been denied their appeal rights.
Thanks, Leanne. The short answer to that is yes, and I would say that that's true across the board, not just for Centrelink debts, but for debts, whether that be you know, arising through buy now, pay later accounts, through mortgages, through personal loans. There's kind of two main categories, I guess. There's debts that a victim survivor might have been vaguely aware of but didn't realise they were personally liable, and many sort of company debts will fall into that category, or debts that they were led to believe were actually joint debts but turn out to only be in their name. And then there's a category of debts they had no idea even existed, often until they seek advice, and then we go about gathering information and requesting documents for them. I would say with the Centrelink debts that come through the door, many of our clients didn't know about the debt until relatively recently, and this could be quite a historic debt as well. And that question around, you know, debts that they don't understand, I think that's the predominant feature there is victim survivors saying to us, I don't know how this happened. I don't know, you know, how all of this came to be. And now I'm really stressed at the prospect of having this debt hanging over my head and not being able to get the Centrelink benefits that I think I should be entitled to at this stage of my kind of recovery process. In terms of their ability to appeal or being denied appeal rights, we would usually defer to our friends at Welfare Rights as the experts in the social security space. But we are constantly, it feels, referring clients to them, where we will be explaining to our clients, we can assist you with all of these debts and all of these financial matters and help you untangle all of this economic abuse you've experienced, except for this Centrelink debt, because the legal climate, I guess, and the legal system is so complex that there are experts who need to really unravel this and try to work out how to effectively undo things that often their perpetrator has done without their knowledge.
This is really the beauty of having this session and the kind of collaboration between all of our organisations. We can raise awareness of these problems, because I'm sure that you at Redfern Legal Centre and us at our member community legal centres that specialise in social security are only seeing the absolute tip of the iceberg, and we really need to raise the capacity of the whole sector to be able to recognise and refer these matters for assistance and hopefully change the law to make all of that easier. So the next question is for everyone. Where a person sells their family home, the proceeds are disregarded under the assets test for 12 months. That's to give them time to purchase another home. So why shouldn't a person's interest in their former home be automatically disregarded for 12 months where their ex remains there?
That's a very good point. I agree. It should be. And at the moment, I think they really rely upon people applying for the asset hardship provisions, and most people don't even know about them. You know, I have workers regularly ring up and I'll say, well, have you considered this? And they won't have known, their client won't have known, that Centrelink won't have suggested it. and you know, the great thing about that provision is that it can be extended for another 12 months. So there's the first initial 12 months, and it's really very easy to extend it for another 12 months. So it would be quite realistic, I think, to do. That's an excellent idea.
The next one is for, sorry, did Jasmine or Beck have any further response to that? Okay. So definitely one to explore. Next, hi Jasmine, Beck and Pamela. Do you see many cases where Centrelink accepts that a woman who's ostensibly in a couple relationship is not a member of a couple, given the coercive control and lack of commitment?
Yeah, so this is where you know, I mentioned the Section 24 discretion earlier. You know, it's not common that we see it get up, I would say. Do you agree with that, Leanne? Like, I wouldn't say it's like, yeah, we see a lot of success with it, but I've had some success with it. And you know, in that instance, that particular client had even married the person, and had a fair bit of evidence, but it was a bit sketch sometimes in some places, and we were still successful. So I just want to say that there's a bit of hope, like you can be successful in that, but yeah, I mean, I don't know if others have got.
I was just about to say that perhaps the subtext to that question is just that when we go to government asking for these reforms, they'll often say to us, it's all fixed. We've got Section 24. So I guess the question is really, how often is that discretion being used, especially since, you know, the Guide to Social Security law doesn't actually have any examples of domestic violence in it. It talks about, you know, where, for example, where one partner is overseas. So, yeah, I guess the question is whether that discretion is really being used and whether that's enough.
I agree, Leanne. I think that the other problem that when I'm reading an arrow, is that they don't consider it first. Like, it should be legislated that has to be considered first. Actually, what they do is they consider a special circs waiver first. And if that's appropriate, then excellent. And so, you know, I had a client and she was successful in a special circs waiver, but actually she had so many characteristics that would have met Section 24, and then she would have had all the money that she'd paid back to her. But and then, of course, the client was like, oh, I got the waiver at Arrow, let's just accept that. So we didn't appeal it to the SSCSD. But actually, I think she probably would have been successful on a Section 24 because it was so profound. So no, the answer is they're just not applying it.
I think the next question is kind of along the same lines. So this is from Eloise Cox. Thanks for the great presentation. When challenging Centrelink debts, how willing is Centrelink to hear arguments of duress or contract formation where the individual who has a debt in their name didn't know it was taken out? So there was actually no offer and acceptance. Thank you.
Do you want to go, Jasmine?
I can't speak to Centrelink's willingness to hear those sorts of arguments. I will make a broad comment about those sorts of contractual arguments more broadly and about other forms of debt, particularly in the consumer credit space, that generally we have quite a lot of success making those arguments around duress, and there are protections in, you know, legislation around consumer credit that allow us to make those arguments. But I will say that there is a practice in, you know, the banking and financial services sector more broadly of often putting the onus on police, for example, to kind of make that conclusion and say, well, we can't possibly judge about whether there was coercion or duress or identity theft or fraud. We'd rather defer to, this checkbox requirement that the victim survivor be able to produce, an AVO or a police report or a police finding of fraud, for example. So I will make that comment more broadly, that that's something that we advocate very strongly against, and that, we shouldn't be forcing victim survivors into situations of making contact with the police system that might potentially re-traumatize them without providing any kind of concrete assistance in that way. I'll hand over to Pamela to respond directly on the Centrelink response.
Yeah, I mean, again, it would need to go to a special circumstances kind of an argument normally, or a Section 24 discretion argument. My mind wandered to another problem that some of my clients have been telling me about, which is that police are no longer automatically just providing a copy of statements to clients, which means they don't have a copy at their disposal. They can't just go, oh yeah, I've got that in my inbox, or I've got that, and flick forward to me, or take a photo of it. It's sort of like old kind of the instances where they might still have a copy, but now they actually have to go and request that. It just creates yet another burden, like another step in the process. Yeah, Beck, do you want to add anything?
No, just every step of the way, there's like an extra step, another burden on. Yeah, totally with you. Those kinds of things can be dealt with in design.
The next question from Lucia is thinking about how best to relieve survivors of debts incurred due to abuse is great, but we actually need policies to enhance Centrelink access for women in violent situations so they can leave in the first place. Would including Social Security in the national plan go some way to ensuring this need for support is included as a preventative measure?
Yes. So if I could jump in there, it's like this has been a big piece of the Centre for Women's Economic Safety, that we know there is no safety without economic safety. And so we're just so disappointed in the first draft of the National Plan to Eliminate Violence Against Women and Children to see no mention of economic abuse, no mention of social security. And if you want to talk about prevention and early intervention and response and recovery, they've got to be embedded in every single step. We've had further evidence of what we already knew, but Anne Summers' report, which so brutally showed us 60% of women, single mothers, have experienced violence, and yet our national societal response is to make women who are already sort of navigating all of that, be applying for jobs. You've got Parents Next, which I don't think we've sort of even touched on yet, which so, awfully recreates the dynamics of an abusive relationship and requires, mostly women, the majority of whom have experienced violence, jump all of these hoops while they're just trying to survive and look after their children. It's just not real life. And so if we can embed in the national plan, which can inform all of these different systems, which do need to talk together, if we can embed the importance of economic safety, address economic abuse, understand that there is a critical role for social security, then we've got a much stronger basis from which I think to start making a whole range of the changes that we've talked about in this session and more that we're going to hear about in the next two sessions.
We actually met with Minister Ishworth last week, and she did say that, and I haven't seen the latest draft of the national plan, but she did say that economic security would be in there, which is heartening to hear, but that social security specifically will not be, but left it open to being included in the first action plan. So it's something that we'll be following up and working on, and we'll be looking for everyone's support on that. The last question here is from Nicole regarding Leanne's question on section 24 being accepted for my counselling clients and myself, not often. Personally, I have gone to complex case managers at high levels in Centrelink, and I've had significant requests in under section 24 and assets hardship test, and no, in capital letters, no luck at all. I've basically spent time equivalent of 2 PhDs to navigate, appeal, and then beg subsequently, beg for support. I've never had luck with the assets hardship request. Just sending you my comments for your general feedback.
It's terrible because it's listed in, like, you know, having experienced domestic violence is in their policy when you read about the assets hardship request. Like, that's actually in one of the rare moments, as Leanne says, it's not very often mentioned. It is mentioned in the assets hardship part of the Social Security Guide. So it's really terrible. You could appeal it through to an arrow, I suppose, would be a possibility.
I will make a general comment about the difference as well between policies and legislation in theory and in practice. And I think the crisis payment for people escaping domestic violence is a good example of that, where it's great that it exists, but having an inherent eligibility criterion be that you notify within 7 days of your circumstances changing, I think really misses the boat and fails to recognise all of those practical considerations. I can't think of many clients that we've seen in our service who have said, yes, I was aware of that payment, and yes, I was able to apply for it within 7 days of fleeing an abusive relationship with, you know, my kids and the clothes on my back, for example. So I think there is this sometimes missing link between the way policies, payments, discretions are intended to operate and the way they actually operate. And certainly, you know, something that requires ongoing discussion, I think, and thought around where those improvements can be made. And I think we've talked about a couple of those opportunities today, but we could spend hours on it.
Yeah.
Thank you so much. That's a great note to end on, the importance of each of your services in bringing that lived experience, bridging that gap between the theory and the reality of what victim survivors go through. So thank you very much for bringing those case studies along today and for painting that picture for us. Jasmine, Beck, Pamela, really great session. Thank you.
Thanks, Leanne.
Thanks, Leanne.
Thanks, Leanne.
Right.